Good evening. Thank you very much for tuning in to our 9th and final debate of Lent term. My name is Joel Rosen and I'm the incoming president of the Cambridge Union. The motion before the virtual house tonight is, this house believes judges make better law than politicians. From Brexit to human rights, the prorogation, to countless other examples of judicial review, the last 2 decades have witnessed growing tensions between the judiciary and Parliament, which frequently turn on the question of who is best placed to define our laws. On this call, to debate this issue tonight, we have 4 eminent guest speakers and 2 student speakers. Please remember that you can participate in tonight's debate by submitting questions to our speakers in our online form and by voting in our online poll at the end of the debate. Links to both the question form and the poll can be found in the description below. I would like to thank the Cambridge University Law Society for partnering with us for tonight's event, which is open to all. Our debate is held in warm memory of Lord Kerr, who served as the Lord Chief Justice of Northern Ireland and a Justice of the Supreme Court of the United Kingdom. Lord Kerr was due to speak on this motion before sadly he passed away in December last year. Traditionally at the Union, the final debate of each term marks a bittersweet transition. The incoming president chairs their first debate and the outgoing president proposes a motion on a matter close to their heart. After the debate, we head to the bar and raise a glass to the term that's just passed and another to the term to come. This evening, although we may be scattered across the land, we're united in thanking our next speaker, Freddie Fisk, who is about to open the case for the proposition. Freddie is the outgoing president and former treasurer of the Cambridge Union. He is a third-year historian at Robinson College and will be studying for the GDL next year. As treasurer, he extended bursary memberships, and as president, he oversaw a dazzling term card, and his gentle and generous manner was never blighted by the constraints imposed by our current circumstances. Without further ado, it is my privilege to invite my predecessor and friend, Freddie Fisk, to make the case for the proposition. Freddie, the floor is yours.
Thank you very much, Joel, or should I say Mr. President, for those kind words. The title of this debate is provocative and glib. I can say this because I chose the wording. In reality, judges and politicians make different kinds of law. Most of our laws are not written by judges, and I do not intend to argue that they should be. They are written, though written may be a generous word, by Parliament. In the main, that is entirely appropriate and legitimate. But judges do make law, they should make law, and they often do a better job of it than politicians. This is the case for the proposition. The framing of this debate tonight might sound, well, good, maybe a bit moderate, maybe a bit boring, but it's not. The judiciary's right to define the law has been disputed in recent years. From Boris Johnson's attack on judicial review, to the infamous Daily Mail tagline, enemies of the people, to Priti Patel's recent jab at no-good lefty human rights lawyers, judges have come under mounting criticism for exercising authority to interpret the Constitution and define legal precedent. The prevailing argument is that lawyers have been going too far than they ought to in the realm of politics, de facto making laws which only Parliament ought to have the right to do. They therefore impose their own political biases on questions they have no legitimate power to preside over. The purpose of my argument is to push back at this torrent of abuse. Those speaking subsequently on this side of the motion will no doubt make the legal case for judges more compellingly than I will. As a history undergraduate, Zeus will strike me down if I venture too far into the foray of a highly respected QC or a former Supreme Court president. Sticking on home turf, I will therefore make an argument that is more historically rooted, that takes the long view, that judge-made law, largely the common law, has a much better track record than the law laid down by politicians, statute. I also want to make a political argument, that judges have been better at making laws in the interests of the people and have been ironically far more diligent guardians of democracy than those whose stipends depend on it. As such, judges should have the power to make more laws, not less. To turn to my first substantive point, Our most important laws lay within the purview of judges, not politicians. They include the right to life. It's worth noting that the law against murder was never codified in statute and exists only in common law, though a precedent for which I'm sure a lot of people are very grateful. The right to property, the right to travel, freedom from torture, the right to trial by jury in criminal cases, freedom of expression and freedom from detention without trial, access to justice, the concepts of innocent until proven guilty, and equality before the law. These laws, common laws, ensure a basis of residual liberty where there is no statute to the contrary. They are judge-made in the sense that they were enforced by the courts long before they were codified by Parliament or by the European Convention on Human Rights. These laws are seminal. They have formed a basis for some of our most important modern-day laws, from grievous bodily harm to data protection to the modern-day Slavery Act. Judges have laid the way and politicians have followed. These laws are also foundational. Their provision enables other laws to be applied fairly, and it is almost impossible to think that democracy might have emerged in the UK without the basic rights they safeguard. Unlike the plethora of other laws which we must abide by in this country, they are almost universally accepted and universally good. Politicians have done their best to undermine the good work of our liberal legal system. In the long history of English Parliament, our representatives have passed successive laws enforcing press censorship. They have suspended habeas corpus regularly to deal with the fear of revolution, revolt, or more recently, terrorism. They made torture permissible in particular cases, notably treason trials. They have systematically discriminated against certain groups based on gender, religion, race, or social standing. Today's governments have been better, but only to an extent. Acting under electoral pressure to be tough on crime and defeat terrorism, our governments have passed a series of laws which are both illiberal and disproportionate in relation to real threats. One only need look at New Labour's abysmal record on civil liberties to see that even the most allegedly liberal governments need closely watching. A more recent and equally alarming example is Pretty Propel's proposed police crime bill, which is being rammed through Parliament this week. This could allow individuals attacking statutes to serve longer sentences than rapists. Of course, any law has the capacity to be enlightened or despotic, and Parliament has passed plenty of benevolent laws amongst the malevolent ones. But I do contend that judge-made law is the more structurally progressive. This last point might be controversial, since an elected legislature is often held up to be the last word of a representative and responsive government. Yet while each law might fit to an appropriate contemporary need, when passed, these soon become outdated. As a whole, the corpus of the laws passed by Parliament are messy and archaic. Many of the statutes still existent today are, frankly, beyond pointless. To take a small example, these include laws against the carrying of wooden panels down the streets of London, putting a stamp upside down, handling salmon under suspicious circumstances, disturbing a pack of eggs when told not to by a policeman, and, best of all, I'm not sure why they needed a new law for this, creating a nuclear explosion. The last two of these were passed as recently as 2008. As this attests, Parliament often passes too much law, which can appear overly pernickety, quickly becomes outdated, and risks simply being ignored or unenforced. Of course, if you'd rather exchange your legal definition for murder to live freely from suspicious salmon, let me know, and I will stand corrected. But I suspect you won't. Judge-made law is iterative. The benefit of the common law and other judge-made law is that it is based on a relatively small selection of basic principles which are adapted to fit a wide range of scenarios where those same basic principles are at stake. Judicial activism has kept our founding principles up to date. Contrary to Boris Johnson's ahistorical jives, this tradition has a long history. Slavery was explicitly outlawed in England in the case of Somerset and Stuart of 1772. This ruling was made 35 years before Parliament abolished the slave trade and 61 years before it abolished slavery. It was entirely based on a precise legal understanding of the writ of habeas corpus, commonly understood as freedom from detention without trial. Some 14,000 slaves were set free in England as a consequence of this ruling. There is plenty of modern-day examples too, but I will leave it to my colleagues on this side of the House to elaborate. The point is that providing judges with a longer leash has a strong record of delivery. Furthermore, in the context of lawmaking, less is more. It is easier to build a consensus around a selection of basic principles. It is also easier to understand. Most of us know and understand the basic principle behind habeas corpus. We do not know the minutiae of the Suspicious Salmon Act of 1986. Judge-made law is not just more progressive in the way it evolves over time, it is more progressive inherently. As a group, politicians embody no single principle. They can enact laws which make one profoundly free and profoundly unfree. Doubtless, there are good judges and bad judges, liberal ones and less liberal ones. But all lawyers receive the same legal training, and it is silly to argue that this training does not transmit an ideology or a way of thinking. This is an essentially liberal ideology, based on the value of personal freedom, fairness, liberty, equality, and justice. From Hobbes and Locke to Blackstone and Bagehot, this ideology has become normative. To argue for judge-made law is thus to affix oneself to a concrete value system. To say that politicians make better law, well, you might as well say you like food. Do you like bad food? Food that's mouldy? Probably not. The opposition will no doubt claim that politician-made law is normatively desirable because it has democratic legitimacy. But this argument is circular. Democracy is not an end in itself, but a tool for ensuring good government in the interests of the people. To suggest otherwise amounts to nothing short of populism. The argument that politician-made law is good because it is decided by the people is backward, since there is nothing common to the people or their representatives which has intrinsic value. What matters is results, whether the law actually serves a public good. By and large, democracy provides an effective means for ensuring laws do not become despotic. But this is not an absolute. As we have seen, when the public or their politicians become misinformed, we have threatening laws which ensue. An assertive judiciary is therefore necessary to protect individual and minority rights in the face of majoritarian tyranny. The opposition may argue that democracy, not liberty, is the most important touchstone, and for this reason, the law of politicians is superlative. But if upholding the principles of democracy is what's at stake, then judges win hands down. One only need look at the prorogation case and the other Miller judgments to see that the Supreme Court is firmly in agreement that Parliament, and not the executive, is the legitimate and primary lawmaker. If only those elected to government had principles, they might be in a better position to mount their own defence. I do not argue that judges should begin legislating on behalf of politicians, but that when they do make laws, they win by almost every conceivable metric, even when playing on home turf. In fairness, they should do. They are the experts. It is bizarre that this point even needs making. The sum of judge-made law is, by definition, more durable, more adaptable, more coherent, and more effective than the sum of politician-made law. But I believe there is something more important at stake than which law is more successful. Throughout this speech, I've made the case that judge-made law is better because it is inherently liberal and protects democracy better. I realise that for those people who don't like their own personal freedoms, or the personal freedoms of others, or our basic constitution, this is not a strong argument. But I make no apology for saying that I think freedom is a good thing, and that those who preserve it are better than those who threaten it. Our Prime Minister recently remarked that we live in a freedom-loving nation. That is true, but it's no thanks to him. It is thanks to the likes of Baroness Hale and Lord Bingham that our liberties are protected. And if we wish to maintain that liberal framework in which we operate, judges need more power, not less, to tell the Prime Minister when he is wrong.
Thank you, Freddie, for that bold opening. We have a question from an unnamed member of the audience for you, which is, do you have specific examples of where the common law protects human rights better than acts of Parliament, in particular the Human Rights Act of 1998?
Well, as I mentioned, the law against murder is a common law writ. It is not originally statute, although, of course, the Human Rights Act contains the right to life. I don't necessarily think it's important that the common law has now embodies principles which statute does not. I think the purpose is that common law has historically embodied those principles.
Thank you very much, Freddie. We now turn to our first speaker for the opposition, Lord Jonathan Sumption. Lord Sumption is a historian and former barrister who served as a senior Supreme Court judge between 2012 and 2018. He delivered the 2019 BBC Reef lecture series on the subject of law and the decline of politics. Lord Sumption, the floor is yours.
Jonathan, you're mute.
Thank you. I think that the first thing to be said is that we need to have a very clear idea of exactly what the issue is that we are debating. Nobody denies for a moment that the courts have an important role to play in controlling the exercise of public power, irrespective of the answer to the motion which is before the House at the moment. But the motion requires us to consider whether judges make better law than politicians. That therefore assumes that they do make some law. Otherwise, there's not much point in our being here. At the moment, as we speak, the great majority of law is new law in the sense that it is legislation. And the practical choice that we face is whether principles of law which respond to new problems are better devised by Parliament or by judges. Historically, we have had from Mr. Fisk a large number of rather archaic examples to illustrate his point. The reality is that most people, I think, would feel that the record of both has been distinctly patchy. We need to remember, for example, when we think about Freddie Fisk's various examples, that throughout the 19th century, just about every moment of progress in the improvement of employees' rights was achieved by Parliament, quite often in the teeth of judges who were persistently opposed to any regulation of the law of contract, and certainly strongly opposed to the operation of trades unions. There have been other periods when judges have been more liberal than Parliament, and periods when they've been less liberal. There is no consistent historical pattern. The main problem, it seems to me, about the argument that you have just heard is that it doesn't address the question, what is good law? What is better law? By what criteria do you decide whether a law is good, bad, or indifferent? And it's all very well for Freddie Fisk to tell us that judges make better law, but if he cannot tell us what better law is, then how does he know? In the nature of things, the question whether a law is good, better, or best is a matter of opinion. There is no agreed test for deciding it. I may regard a proposed law as wholly admirable, which you think is entirely disgraceful. So the basic question before the House really boils down to this. How do we resolve our differences of opinion about the kind of laws that we want in a democracy? Look for a moment at some of the big issues of today: privacy, environmental protection, immigration, housing. I may care passionately about the privacy of my data and object to the police having access to it, while you, sir, consider that it is more important to suppress crime. I may think that protecting the environment is the top priority, whereas you think that economic growth is equally important if we are going to eliminate poverty. I may believe that receiving refugees from less fortunate parts of the world is an urgent moral duty, whereas you think that large-scale immigration is socially corrosive. Now, our differences of opinion on issues like these will usually be incapable of being tested on wholly objective criteria. We may have different political starting points. We may have different moral outlooks. We may have different economic interests or different degrees of sympathy for particular groups. People who want judges to make their laws are usually educated, comfortably off, middle-class people of liberal instincts like Freddie Fisk. They want judges to make the laws because they think that judges have the same outlook as they do themselves. But our society has to encompass a much wider range of opinion, interests, and backgrounds than that. It even has to encompass people who are, dare I say it, actually not very liberal. What about people whose outlook is very different from that of the average judge? Are their views not entitled to any consideration? The answer to the question before the House, I would suggest, is that the essential requirement of good law is not intrinsic excellence, a question about which no two people will ever agree. The essential requirement of good law is legitimacy. People must, in a sense, own it. They must feel in a democracy that they have had some input into the process by which it is made. Because without that, they have no reason to accept laws with which they disagree. Politicians, in this context, means members of the elected legislature or ministers legislating under powers delegated by the elected legislature who are answerable to it for what they do. If we don't like the laws which they have made, we can sack them, or we can sack the political party to which they belong. In contrast to that, we have no input into the decisions of judges, and we certainly cannot sack them. Now that difference reflects a fundamental difference between their functions. It is absolutely right that public opinion should not affect the decisions of judges in particular cases. It is absolutely right that judges should be unsackable. The reason why these things are right is that the job of a judge is to apply the law rather than to make it. If we don't like the law, we should not be blaming judges. We should be blaming our representatives in Parliament who made it or failed to change it. Once judges start making law instead of just applying it, we are effectively transferring decisions which are critical to the future of our society to a body of technical specialists who are constitutionally answerable to nobody. It is worth asking why it is wrong that public opinion should influence judicial decisions, but right that public opinion should influence legislation. The answer to that question, surely, is that it reflects a profound truth about the way societies work. Adjudication and legislation are utterly different jobs. They are confided in civilized states to different people with different duties and different lines of responsibility. This motion seeks to confuse the two things, and that is why this House ought to reject it.
Thank you, Lord Sumption. We have another question submitted from the audience, this time from John T. Lynn. And he asks, is what happened with the Anti-Terrorism, Crime and Security Act of 2001 and the decision in Belmarsh not an example of the independent judiciary being capable of better protecting fundamental human rights in the legislature?
It is an example of the judiciary controlling an excessive exercise of executive power. That's not the same thing as conferring a lawmaking power on judges. But having said that, I would certainly agree that there are aspects of the Human Rights Act that do invite judges to make law, and that is what is wrong with that particular aspect of the Human Rights Act.
Thank you for that answer. We now turn to our second speaker for the proposition, the Right Honourable Lord Neuberger. Lord Neuberger is an English barrister and judge who served as President of the Supreme Court from 2012 until 2017. His background is in complex financial and commercial contractual disputes property law and professional negligence. Floor is yours.
Thank you very much. Congratulations on your accession to the presidency, and also to your predecessor on his excellent speech, which I thought a bit odd to describe, for a historian to describe a historical analysis as archaic, but there we are. I think that Lord Sumption overestimates the extent to which Parliament ruled the roost in terms of making law, and still should rule the roost. Both Parliament and judges have always made the law. Over the past few hundred years, the judges have made less of it and Parliament more of it. But he mentions things on which opinions differ, like the balance between privacy and freedom of speech. And let me just take that as an example. Parliament has laid down only in the broadest possible terms the existence of a right to privacy and the existence of a right of freedom of speech. It has been up to the judges to hold the balance and decide in individual cases and develop the law in individual cases as to how that balance is to be held. That is merely an example, but it just shows that Parliament and the judges make the law. They always have done, and on the whole, they respect each other's territory. That's not the issue this evening. The issue is which of them makes better laws when it comes to their area of making laws. And the answer is the judges. And that is for a number of reasons. It is not that they're better people than politicians, but it is because judges have the appropriate experience. They're selected for their ability to make law and understand the law. They receive proper training. They're full-time professionals. They have little in the way of an agenda. They receive principled and dispassionate arguments on which they decide the cases, and they are concerned ultimately simply with getting it right. The great majority of politicians tick few, if any, of those boxes. Let me say a little bit more about them. Experience. Virtually all High Court and above judges, and indeed circuit judges in this country, have been practicing lawyers and have seen the law at work day in, day out. Believe me, explaining the law to a client with a problem or arguing about the law in court really helps you appreciate what constitutes bad law. Practicing lawyers have a very good idea of how the law works. Most politicians have no comparable experience. Selection. Judges are selected by an experienced panel of lawyers, judges and lay people, all of whom are looking specifically to appoint people with appropriate track records and qualities for being good judges, which includes lawmaking. MPs, by contrast, are selected by constituency political parties and then by the electorate. And I've never heard any potential or actual candidate's ability at making laws being played out as an important part of his or her ability to be an MP. Training. However well qualified you are for a job, good training will make you better. All UK judges are required to attend carefully tailored courses in judging before they start, and to go on refresher courses during their judicial careers. MPs have no required training, and I doubt there's much informal training. When I was President of the Supreme Court, I suggested to the Clerk of the House of Commons that we could invite MPs to come over and have tea and discuss lawmaking and the like. He replied that it was an excellent idea, but it had one drawback. I asked him what it was, and he replied, none of them would come. Full-time professionals. Judges spend their whole time administering the law, deciding what the law is, how it is to be applied, how to develop it. Politicians spend most of their time on things that have nothing to do with the law, keeping constituents happy, pursuing their careers, making speeches, keeping in with and keeping up with the media in a 24/7 world, trying to become ministers or running departments when they are ministers, keeping up with the party, keeping in with the whips. Yes, of course they do some lawmaking, but only on the side. No agenda. I do not pretend that judges have no biases, no prejudices. Of course they do, they're human. But most judges do their best to be as fair and open-minded as possible when asked to decide any issue, including developing the law. None of them is perfect, but they're streets ahead of politicians for whom the pressure to look strong, the pressure to toe the party line, the pressure to keep the media happy, the pressure simply to go with your gut because there's not much time to do anything else, means that there's often little real thinking about legislation. And there's real danger of a politician with a real axe to grind and no objectivity getting his way, a recipe for bad law. Dispassionate argument. Judges reached their decisions after arguments advanced by each side in a professional, cool and informed way, and after taking such time as the judge needs to think about it. And there's an appeal process whereby more senior judges can consider the point afresh and have cool, dispassionate discussions between themselves. Debate in Parliament about laws is normally very curtailed, often heated, and rarely makes any difference to the outcomes, thanks to the whipping system. So MPs do not consider changes in the law with the care and disinterest of judges. Finally, simply getting it right. Judges remain in the job until they're 70, it may be 75 soon, but MPs are always at risk of being deselected or being voted out. This means they're much more likely to support popular but bad legislation or to oppose unpopular but good legislation simply out of self-interest or self-preservation. That's not a criticism, it's a fact of political life in a democratic society, but it significantly hampers politicians' ability to make good law and to avoid making bad law. With no such pressures, judges simply strive to make good law and to avoid making bad law, and a bit of bad publicity is little more than water off a duck's back. Before I turn to the evidence briefly, let me make it clear that I accept, of course, that politicians have some advantages over judges when it comes to lawmaking, but those advantages pale into insignificance when compared with the advantages of the judges. Politicians can claim greater diversity and being closer to social conditions, although being close to the public has its downsides in terms of wood and trees. Another potential benefit for politicians is democratic accountability, to which Lord Sumption referred. But it's not relevant to making good laws in themselves. It's potentially relevant to people respecting and therefore obeying the laws made by Parliament. But that brings me to the first piece of evidence. Polls, of course, have to be handled with care. But the consistent result of polls over the past 25 years is that the public trust the judges far, far more than they trust politicians. The most recent 2020 Ipsos poll shows 84% of the public trusted the judges and 16% trusted government ministers. So whose lawmaking powers are likely to go down better with the public? Whose laws are likely to command more authority, I ask? My second piece of evidence is referenda. The slow but unmistakable emergence of referenda over the past 50 years is a sign that politicians are losing confidence even in their own ability to make laws. There's no such sign of judicial despair. On the contrary, as the two Miller cases show, the judges are prepared to step up to the plate, even in tricky cases. My final piece of evidence is provided by that formidable historian, commentator, ex-barrister and ex-Supreme Court judge, Lord Sumption. The basic theme of his impressive 2019 Reith lectures was that judicial lawmaking has undermined parliamentary legislation. He thinks that that's a bad thing. He may be right, or he may be not. But that's not the point for this evening. The point is that the shift in lawmaking power has been achieved partly by the judges themselves, for instance by developing judicial review, and partly by politicians through legislation like the Human Rights Act, the HRA, giving the judges a positive duty to extend their powers, indeed entitling judges to try and reformulate statutes when they don't comply with the Human Rights Act. And all this has gone on fine for 20 years. So politicians seem to think that some lawmaking power should actually be transferred to them, to the judges from them, and judges seem happy to take it on. I reckon that's a pretty good indication of the answer to the question in this debate. Thank you very much.
Thank you very much, Lord Neuberger, for that powerful speech. An unnamed member of the audience has written in with a question for you, which is, do you not accept that Parliament can act more quickly to make laws than the courts, who can only decide on a law when a case is actually brought before them?
That's That's a perfectly good point. Of course, a case comes before the court because there is an issue of law, if it involves an issue of law, which needs to be decided. But that means that judges can't go wading in and deciding where the law needs changing in their own view. They change the law when the case comes before them. Both the judges and Parliament can act very quickly when a case needs to be decided very quickly, or when legislation needs to be passed very quickly. And I wouldn't fault Parliament for dealing quickly when it has to deal quickly, and I wouldn't fault the judges either. But it's perfectly true that the judges dine, as it were, table d'hote, whereas the Parliament dines à la carte. Parliament can go wherever it wants. Judges are disciplined by the cases they have that come before them. But of course, the cases that come before them are cases that involve points of law that are difficult and need to be resolved. So it's appropriate that they are resolved.
Thank you very much. Our second speaker for the opposition is Professor Alison Young. Professor Young is a fellow of Robinson College, Cambridge, and has been the Sir David Williams Professor of Public Law since 2018. She has written many books on public law and constitutional theory, including the UK Constitution after Miller, Brexit, and beyond. Professor Young, the floor is yours.
Thank you very much, Mr. President, and congratulations on your recent election. We have heard so far from Mr. Fisk, who's given a series of examples of cases, perhaps missing some of those cases that don't necessarily protect liberal principles. So for every Miller decision, there is a Roberts and Hopwood claiming it to be outrageous that it should dare to pay men and women the same wage. We've also heard that good law depends on how legitimate it is, from Lord Sumption setting out a strong case for the democratic legitimacy of law enacted by elected representatives. We'd heard from Lord Neuberger that we might have a situation in which politicians aren't necessarily trained to make law. I might perhaps draw to his attention that the wording of legislation is actually drafted by government lawyers, the Office of Parliamentary Counsel, who are legally trained in order to put the legitimate debates we find in Parliament into those precise words that can then be enacted and relied upon in the future. But what I want to draw your attention to this evening is, drawing on my old habit of wandering into legal philosophy and legal theory, is asking a little bit deeper what we mean by good law, what we mean by better law, by thinking carefully about what makes law good at its job. The job of the law is to regulate the behaviour of individuals. So we can look at the work of legal theorists like Lon Fuller, Joseph Raz, or Lord Bingham, looking at aspects of the rule of law. And they will tell you that what makes good law is that law is general, public, prospective, coherent, clear, stable, and practicable. And I would like to put it to you that that is precisely the kind of law you see made by politicians, but not necessarily in the law that you see made by judges. Politicians enact legislation that can deal with general matters. Judges, as we've heard, deal with specific issues, focusing on the parties appearing before them. So we've had some discussions to date on the human rights, because we often see human rights as an area where we think perhaps judges do a better job than Parliament. But you have to turn to Parliament for the legislation that provides these general protections of rights. Things like the Human Rights Act 1998, which has already been mentioned, or the Equality Act 2010, which provides a broad series of protections of rights and ensure that we don't have an element of direct or indirect discrimination on a wide range of protected characteristics, such as gender, race, religion, disability, gender reassignment, marital status, sexual orientation, and age. But it's important to recognise that these laws don't just say that you can't do the following acts, they also provide a means of facilitating rights, of ensuring there are systems and mechanisms in place to enable you to practice these rights, not just ensuring that the rights cannot be harmed. Politicians make law in public. They debate bills in Parliament, in the public, under the watchful eye of the media. Acts of Parliament are published, ready, available to be read and relied upon. Politicians enact legislation that looks to the future. Their aim is to change law. Now, I accept that judges too decide cases in the public. Judgments are published, they're widely available. Judges may find that their hearings and judgments are thrust into the spotlight of the media, perhaps subject to disparaging criticism by various aspects of the media if they seem to decide things incorrectly. But judges look to the past. They tell you when laws have been broken, when rights have been harmed. They don't provide a means of ensuring that rights are not going to be harmed in the future, nor can they provide lovely detailed mechanisms that provide a means of facilitating your rights, so you know when you can and cannot enter a series of contracts, or when you can or cannot protest peacefully. So take, for example, cases like Bellinger and Bellinger to do with transgender rights. In that case, the courts can have a look at the decision and have an assessment of legislation to see whether convention rights are breached in a situation where a marriage is only allowed between a man and a woman when their gender is determined at birth. Judges can point out that that breaches convention rights. But what judges can't then do is tell you precisely how to ensure we protect those rights in the future. That takes legislation enacted by politicians. So we have the Gender Recognition Act 2004, which provides these frameworks. And this legislation is not just enacted purely by politicians. Politicians can have pre-legislative scrutiny, asking interested public groups, stakeholders. It also has post-legislative scrutiny. So the Gender Recognition Act 2004 itself was subjected to post-legislative scrutiny to see how this was working, whether it was or was not protecting rights effectively. That is not something the courts can do or the courts should do. Or we can take cases like Nicholson to do with the law on assisted suicide. The courts can go away and say, do we think convention rights have or have not been breached in certain circumstances? Do we need a right to assisted suicide? But if we need that right, we need politicians to sit down and set out the rules that will facilitate that right in particular circumstances. If we have a right to assisted suicide, does that mean that should only be available for the terminally ill? Should we have a system of living wills? We need politicians to debate these issues and also set out things like, do we need medical practitioners? If so, do we need medical practitioners involved to be able to say, well, this is not something I should be required to do on conscientious grounds, perhaps for reasons of religion. Politicians are better placed than judges to assess all of these different interests, points of view. So it's not just that it's more legitimate, which as Lord Sumption has convincingly explained they are, but they're also better placed to look at all these different competing rights and interests, balance them, and come up with a better solution. Judges just see the parties before them before the court. They might hear things from interested parties intervening, but again, it's up to those wanting to intervene to decide to go away and do so. Courts can't proactively seek them out in order to have a range of points of view, nor should they do so. But I also, as Lord Sumption has previously explained, want to reinforce what you are not being asked to agree this evening. You are not being asked to decide whether judges should never make the law at all, nor are you being asked whether judges should be passive, never be in any way, shape or form protecting individual rights, and only ever interpret legislation according to the precise wording of Parliament as set out. So I agree that there are some examples of legislation that I don't think are examples of good law. So I don't agree with repealing the Fixed Term Parliament Act, nor do I agree with a lot of the provisions that Mr. Fisk has already mentioned in the recent Bill of Police Sentencing and Crime Bill, which I agree have a serious potential effect on the right to peaceful protest. But just because I think politicians can and do make imperfect laws does not mean that I think judges are better at making law that is general, published, open, clear, and can facilitate protections of rights. What that means is we need better politicians or better lawmaking procedures. It doesn't mean we should ask the judges to step in and make the law instead. So I would argue that judges can and do develop common law principles on an incremental basis. I would argue that courts should go away and interpret legislation in a manner that is able to protect rights. And I would also argue that judges should be there to ensure that long-standing constitutional principles are not accidentally eroded by politicians. But I do not think that this provides any evidence for the case that judges make better law than politicians. What it shows is judges are better at judging than politicians. So I would argue that if you want a society in which we have law that is clear, prospective, published, is able to facilitate and not just ensure rights are not eroded, then I would urge you this evening to reject this motion. General, public, prospective, coherent, clear, stable, and practicable laws are more likely to be made by politicians, not by judges. Thank you very much.
Thank you, Professor Young, for that incredibly clear speech. You also have a question from a member of our audience who writes, is it entirely fair to say that law made by politicians is stable with regard to the infringements on the ECHR through recent policing and national security legislation, such as the 2001 Anti-Terrorism Act?
Okay, thank you very much. So what we mean by stability is law that is able to be found, that has an aspect of longevity to it and isn't necessarily subject to quick erosion. Now, there's always going to be elements of laws that are unstable, elements of laws that need to be changed. Sometimes there's always going to be aspects of law that we don't agree with, that we think are not providing good rules. In those situations where legislation is enacted that perhaps isn't necessarily how we would want it to be, or doesn't necessarily reflect how society operates at the moment, then you can deal with that more effectively by having general provisions in legislation, with the courts being able to adapt what they mean in light of specific circumstances to ensure enduring stability. So it may mean you need both working together, but I do not think that detracts from the fact that politicians would do a better job than the courts.
Thank you. We'll now hear from our third and final speaker for the proposition, Hannah Markham QC. Alongside winning numerous awards as a family silk, she is the vice chair of the Family Law Bar Association and founded the organisation Family Women in Law. Hannah very kindly agreed to step in on behalf of Professor Joe Delahunty, who had to pull out of this debate last minute on account of an urgent case. The floor is yours.
Thank you, Mr. President. And thank you, Mr. Fisk, as well, for your kind invitation. I think I probably am owed something by Professor Delahunty, particularly coming in after the tour de force of Professor Young. Whilst I've sort of set out my speech, I think I must deviate from some of what I had said to respond to the powerful submissions on behalf of my learned friends who have come before me. In particular, I will pick up Professor Young's point as I go through, that judges and the decisions in court don't provide a means to ensure rights are protected in the future. I think quite contrary to that, that is exactly the purview of the judge. And we have many examples across the history of where judges have stepped in to ensure that the rights and responsibilities are protected. Sir Mark Headley was a High Court judge in the Family Division. He's written a book about being a modern judge, and he explores how that role has developed in response to the demands of an increasingly complex society. He recognised the powers judges have to make discretionary decisions about the cases that come before them. Those discretionary interpretive powers allow judges to have greater flexibility in reviewing and analysing the law than, for example, politicians. I argue the judges' independence and ability to stand back away from some politically charged decisions stand them in better stead to review and consider with care the law that they interpret and then go on to make. Further, Sir Mark Headley speaks of the requirement in judges not only to act with integrity, to be beyond corruption, but with a real understanding of the needs and aspirations of the society they serve, to hold a humane understanding of people, a deep sympathy with human frailty, and a desire for a just and ordered society. And he says that must, he says, be an indispensable feature of the judiciary. Now, I'm not saying that the politicians lack these qualities, but they, unlike judges, are driven by their party politics, the cyclical aspect of the election, of the re-election, the manifesto of their party in any given period of political rule. You've heard already, those that have spoken before me, of the ebb and flow of the political life. Judges are different. Judges have a different stance. Judges have a different take. Judges' views are different. They serve society in a different way. The holding of the society's trust and the power that judges have held across the years, but have also become developed and focused over the past decades, not least with the changes brought about to ensure the protection of one's individual rights through the European Convention of Human Rights is significant. The role of the modern judge is to ensure that those rights are protected by our lawmakers, and they use their role to make law and to effect changes in the law. For example, picking up on Professor Young's view of the Gender Recognition Act, were it not for the judge's decision in the Goodwin case, would our government even have given effect to the Gender Recognition Act in 2004? They were forced away from their navel-gazing to look at the rights to transgender people through the judicial decisions. Brings us to the question, what do we mean by making law? Where does law come from? Yes, I accept in some ways it's a circular argument, but by pulling the government up on the matters they have not given careful regard to, the judgments they make, law is changed. Is that not lawmaking? The judges, in effect, review the law made by the politicians. They check it's fit for purpose, and it does not offend the principles of the Human Rights Act. Judges also interpret what politicians mean, or can properly have been meant to have said, the purposive interpretation which judges take as makers of law. I'm sure both Lord Sumption and Lord Neuberger have spent many hours listening to debates as to what was meant when law was made, and argued whether or not Hansard assists, or whether or not the propositions in Pepper and Hart even allow consideration of what was said in Parliament. A recent example of this is the McConnell case, another transgender case, against the Secretary of State, the Registrar General. In that case, the court focused on the ordinary meaning of Section 12 of the Gender Recognition Act. The lead judgment came from the Lord Chief Justice, Lord Burnett of Malden, who did not hesitate to attribute to that section of statute a meaning which will be used to interpret other cases and will be used by politicians in furtherance of their lawmaking. Judges also read down the law to give it a meaning which is appropriate to prevent incompatibility with the human rights, or to declare that the law is simply not compatible with the human rights. And it's not simply a case of the human rights of those that come before it. There are many public interest cases that go to the Supreme Court and are heard and tested there because of the public interest points and the points of principle that are contained within those judgments. If I may, I'll draw attention to two particular cases in the field of surrogacy laws by the then President of the Family Division, Sir James Mumby. He considered challenges brought by the respective applicants to the current surrogacy laws, to parental orders, and the President of the Family Division was able to consider the application of those laws and the extension of those laws within the confines of the best interest principles relating to children. It had been argued that the law relating to surrogacy laws in the UK had been in desperate need of reviewing and updating. Most of that law was written in the 1980s, the time when surrogacy was very much in its infancy and almost thought best to be discouraged. However, attitudes have changed over the course of the intervening 30 years, and surrogacy is now accepted as an increasingly popular route to parenthood. Although unsurprisingly, the law now governing that area has been perceived to be out of date and unfit for purpose. Any review of it has been lost to more pressing political issues, for example, Brexit. So it's been left to the court to review it, to update it, to make new law, to ensure that it is fit for purpose. In the first of those two cases, Re-Ex, in 2015, Sir James Mumby, in his role as President of the Family Division, determined the 6-month time limit imposed by the Human Fertilisation Embryology Act, is imposed, and had it been strictly interpreted in an absolute way, it would have brought a bar to many, many parents and many children to have parental orders made. Parental orders being the transformative order that gave parental rights. The President in that decision determined that he would not interpret the 6-month limit in an absolute way. Again, the President considered how he would read down statute in a way to ensure the essence of the protected rights of those who came before him. He made sure that the rights were not being impaired, and that what was being protected by the law that he was considering and making was both practical and effective, and not theoretical nor illusory. In a slightly different way, in 2016, again in a surrogacy case, the President, Sir James Mumby, was asked to consider reviewing surrogacy rules in respect of single parent applications. Section 51(1) and 2 of the Human Fertilisation Embryology Act permitted only a couple to make applications for parental orders. Unfortunately, in that case, the court declined to use its powers to read down the law, saying that the application of the law to the changes in society and the evolving needs of those who engage in surrogacy arrangements needed to be made by politicians. However, having failed to persuade the court to read down the case law in that way, the father then made the case that the provisions of Section 54 were incompatible to his Article 8 rights and those of his son, and he sought a declaration of incompatibility. On this occasion, Sir James Mumby did accede to that request and determined that it was a breach of the applicant's human rights and the legislation was incompatible with those rights. In that judgment, and in the judgment that came before, the court, through its lawmaking, was able to bring about swift and effective changes to law that needed updating in ways that politicians and politics didn't do and couldn't do because of the cumbersome way that they need to review, reflect, and make changes. As recently as 2020, the Supreme Court has considered its powers, the powers of judges to review, reconsider, read down, declare as incompatible, or interpret in a purposive way statute, and they've done so in a number of cases. In fact, I resisted the urge to cite those where Lord Sumption has taken his part in making or changing or interpreting the law, and there have been many, and we practitioners are grateful to him and to Lord Neuberger for the judgments and decisions they made when they were sitting in the Supreme Court. Instead, I turned to the case of the Queen versus Steinfeld and the Secretary of State. And you may have noticed I'm citing quite a few cases of challenges against the Secretary of State, challenges brought by the people of England and Wales against the government. That shows in itself the way in which the judges and the courts are better at making law. They are the only ones that can stand up to the government, to call them to task, to ask them to listen. In that case, in Steinfeld, the lead judgment in that case is that of the late Lord Kerr, and it's important when considering the approach to the judiciary to its role when making law, reviewing law and expanding the scope of law. Forgive me from reading from that judgment. Paragraph 54 of the judgment, Lord Kerr recognises how the court has been encouraged to refrain from making declarations of incompatibility because it was argued on behalf of the government that the decision not to take action extending or abolishing civil partnerships was one that fell squarely within the field of sensitive social policy, which the Democrat-elected legislator was preeminently suited to make. However, he and the other judges of the Supreme Court sitting beside him had regard to what was actually happening on the ground in respect of political debate, speed of change, and what was needed at that point in time. Lord Kerr held that the argument had significantly less force if the decision not to take action at present did not pursue a legitimate aim, but it must nevertheless be considered for the base it might have. He considered with care the court's powers when considering to make a declaration about incompatibility under Section 4 of the Human Rights. It's a discretionary power, and the court may make a declaration of incompatibility only where the court clearly contemplates that there'll be circumstances it's necessary. And Lord Kerr reminded us that there are circumstances when self-restraint should be exercised, and the court should not make such a declaration, and not call for remedial review of primary legislation. But he said this too: in my view, there is no reason that this court should feel in any way reticent about the making of a declaration of incompatibility. To the contrary, I consider that we have been given the power under Section 4 of the Human Rights Act to do so, and that in the circumstances of this case, it would be wrong not to have recourse to that power. So I finish with this: if not the courts, if not the judges, in their independence and the power invested in them by society, to explore with an open mind, to apply their discretion, to look at the changing social norms, if not the judges to challenge whether Parliament needs to review and reflect, who then? How does law become new law? How do we affect change? In my submission, the cases I'd identified illustrate that judges are better at making law, are better at affecting change, and they make the law through their judgments and through the changes that follow those judgments. Their approach is more nuanced. It's directed to the evolving and changing needs of societies and the specific facts and the public interest points in the cases that come before them.
Thank you very much, Hannah, for those comprehensive remarks. If I may, I'd just like to relay a question that one of our listeners has written in with. Robert Vincent asks, as seen in the USA, the nomination process for federal judges is highly politicised, as are those who are nominated. By pushing political power explicitly towards the judiciary, how do we avoid the judiciary becoming politicised?
Well, I think Lord Neuberger addressed that when he set out a little bit about the way in which judges are appointed. There is a careful process through the Judicial Commission. It allows independence and integrity and a rigorous assessment process. There are not only former judges on the panels, but also independent people from across industry, which prevents political appointments and allows the integrity and independence of the judiciary that I've just set out.
Thank you very much. We now turn to our final speaker for the opposition and our final speaker for the night, Saifullah Shah. Saifullah is a first-year law student at Downing College, and he won this slot through open audition. The floor is yours.
Thank you. We live in an age in which faith in politics is at an all-time low. Politicians are viewed with disdain and are routinely eviscerated in the court of public opinion. Each promise made and each promise broken are but pebbles in the tide, accelerating the alleged erosion of parliamentary and executive legitimacy. Amid this chaos, it has become customary to look to the courts to solve questions we feel politicians are not fit to address. Their legal wisdom, perceived stoicism, and unassailable objectivity, presenting an appealing alternative. Yet there is a deceptive simplicity in this constitutional farcilos. As Hume observes, a chasm may often lie between what is and what ought to be. If I could say but one thing tonight, it would be this: that while turning to the courts at the expense of politicians has its benefits, it is a dereliction of duty both to our Constitution and the democratic values that lay its foundations. It is important to note that this is a conceptual discussion rather than an empirical observation. The motion does not ask whether Lord Neuberger or Lord Sumption made better law than David Cameron, if Lord Bingham was a superior jurist to Tony Blair. Simple questions yield simple answers. Rather, this motion raises questions of politicians' and judges' respective roles, not how they are often exercised. Better law, I submit, is that which is better by virtue of process, rather than effect. Law which has acquired primacy through its journey, rather than destination. The law of politicians, I argue, is fruit from a superior tree, regardless of how it may taste. A system may survive if its participants disagree with its results, but is doomed to fail if they disagree with its process. As Lord Sumption has mentioned, what makes such a process acceptable is legitimacy. and it is through the lens of legitimacy that we lay siege to the motion tonight. I have but laid the foundations to my key argument thus far. I now turn to the hammer and anvil between which this motion lies: parliamentary sovereignty and democracy. To many of us, first-year law students and eminent jurists alike, the concept of parliamentary sovereignty needs no introduction. Defined by the great constitutional theorist Dicey, it is that Parliament thus defined has, under the English Constitution, the right to make or unmake any law whatever, and further, that no person or body is recognised by the law of England as having a right to override or set aside the legislation of Parliament. Regardless of how one views this principle, it lies at the core of our Constitution, and is that upon which all other principles rest. Politicians and judges come and go, but Parliament remains sovereign. It is how things are, and how things have been for a significant portion of our history. It is hard to reconcile this constitutional fact with the motion tonight. If the laws that Parliament makes have such sacred status, if they lay down rules with a degree of permanence that other lawmakers cannot match, then it follows that this law is the best law. Even if these laws can be repealed, the complexity and sluggish pace of the political process makes this harder than it is for an appellate court decision to substantially reshuffle an area of the common law. It is flexible, but not excessively so. If the law of politicians has legislative supremacy under our Constitution, then our Constitution recognizes its superiority to the common law. Sovereignty does not imply inferiority. Thus, politicians make better law than judges due to the legislative process itself. It is important to note that barring logical incoherence, the quality of a law does not affect its constitutional status. Although awful laws have been produced by Parliament in recent years, this has no bearing on its constitutional status or legitimacy. To most, however, it is not enough to say, this is how it is, and therefore how it must be. Having made reference to Hume's guillotine earlier myself, I would be hoist with my own petard if I left it at that. Although a constitutional fact, and largely used as a rhetorical device with no real justification, there is a certain wisdom in the doctrine of parliamentary sovereignty. Its relevance today is largely justified by reference to democracy and politicians' unique position in best fulfilling its aims. The merits of democracy and the place it occupies in our society need no discussion. As I mentioned before, citizens may disagree with individual laws, but if are in general agreement as to how they were made, society is content. At the core of democracy is compromise. Since no opinion enjoys universal support in a civilized society, the outcomes of a democratic process will be a synthesis of multiple competing viewpoints. The best law is that which most effectively achieves this compromise, so it must have the best process at doing so. It is here where politicians most evidently demonstrate their lawmaking capabilities. Parliament is composed of hundreds of elected representatives who generally undertake the role of advancing the views of their constituents. Therefore, parliamentary debates in principle are the most effective tool at simulating national dialogue. Politicians also possess expertise in the art of compromise, so are best placed to address morally sensitive questions that deeply divide our nation. The law of politicians is able to effectively address issues of devolution, education, and finance. The law of judges is not. It follows that politicians do not make better law solely due to a constitutionally superior process, but a process which is democratic and able to solve matters the courts have long avoided. The proposition may charge me with shifting the goalposts in this debate. Perhaps I have to an extent. But to discuss the lawmaking merits of individual politicians and judges, or specific laws that they have produced, would in my view be a moot point. Our Parliament, once the Colosseum of old, is very much the crumbling Colosseum of today, with an opposition as spineless as our government is tyrannical, and a Prime Minister who would see himself crowned king. On the contrary, our judiciary remains as stoic and intellectually virtuous as ever. My friends, when I emphasize principles like parliamentary sovereignty and describe turning to our courts as a dereliction of duty, I'm not suggesting that there is no role for the judicial process, even in sensitive matters. Advocating judicial deference is not advocating judicial sycophancy. The courts have their role, but surely it is for the courts to preserve and protect the process by which Parliament makes laws, not to substitute their own. As wise as judges may be, there exists a slippery slope between judicial activism and judicial hubris, and to suggest that judges make better law than politicians by virtue of process treads dangerously close to the ladder. If our system is broken, then it is our duty to repair its foundations rather than destroy them. The courts have a key role in this. They always have. But judges are best placed to hold politicians to account rather than overthrow them, to improve their law rather than replace it with their own. I conclude that politicians make better law than judges, as that is what our Constitution decrees. Politics may have declined, as the proposition has no doubt demonstrated, but faith in our political process is the only solution to weathering this storm. Perhaps I will be proven correct, perhaps not. All I can do now is echo the words of Edmond Dante in saying that until the day when God will deign to reveal the future to man, all human wisdom is contained in these two words: wait and hope.
Thank you for an edifying and uplifting speech. Batuhan has written in with a question for you, which is, what are your thoughts on the use of ouster clauses and Henry VIII powers in statutes? He writes, the common law has always respected Parliament's sovereignty whilst developing its principles. How can politicians be said to make better laws when they've been increasingly relying on tools to curtail the powers of the courts, whilst allocating the executive broad discretionary powers not subject to scrutiny?
Well, firstly, thank you for the question. It is a valid point. I think, again, the issue of ouster clauses cuts to the substantive value of these laws. And I still argue, as based on my argument, that by better law, having been made through the parliamentary democratic process, they are constitutionally better. Now, with regards to ouster clauses, there is not exactly a tension with regards to this debate between the judiciary and Parliament. When we have judicial review, it is not so much the court substituting law, but throwing the gauntlet back to Parliament, saying, we disagree with this law that you have provided, it is your opportunity to reform it. Again, linking to the latter part of my speech, this suggests that the primary role of the courts is to act as the guardians of parliamentary sovereignty and to help the politicians make their better law, as they always have, not to make better law than that made by politicians. I hope that answers your question.
Thank you. That concludes our final debate of Lent 2021. Thank you to all of our speakers for their wit and wisdom this evening, and especially hearty thank you to Freddie and the Lent team for an incredible term in spite of the odds. We'll see you in Easter. Until then, take care and good night.